appearing in the appeals, Lewin and Diah, and Intercom and the Police Federation.
Good morning.
Good morning.
Yes.
I am Terence Williams. I appear for the appellant. With me, Mrs. Yannick Taylor Wellington, my left.
Yes.
And for the respondent, Miss Kaufman, Queen's Counsel, Miss Talia Mirage, and Miss Althea Grant. Thank you.
Right.
This appeal is being heard together with the matter of the Commissioner of Income versus the Police Federation. And in that matter, my learned friend, Mr. Fitzgerald of Queen's Counsel, appears for the Independent Commission. With him, Mr. Richard Small and Miss Crystal Blackwood.
Yes.
And I believe the team for the respondent would be the same.
Yes.
It is there's a shared issue in the two appeals as regards the power to right to prosecute.
Yes.
Which goes between both cases, and in the Diah matter, I intend to say something about that matter, about that issue, which will be continued in the Police Federation matter, hopefully to make sure the matter is comprehensively dealt with. But the intention is on this side to begin with the issue of our appeal against Diah's acquittal at the Court of Appeal, which I will deal with this morning.
Yes.
Mrs. Taylor Wellington will follow briefly on the issue of sentence raised by the other side, and then that is when we will...
Well, that can be dealt with very, very briefly indeed, can't it?
Yeah, indeed. And then we will transition into the issue of the right to prosecute. And so on the matter then of the acquittal of Mr. Diah, Deputy Superintendent of Police, your Lordships will note that the acquittal by the Court of Appeal was grounded in three principles. One, that mistake of law could be a defense, whether we call it mistake of law or ignorance or uncertainty, that could provide lawful justification or excuse. That the orders of his superiors could provide lawful justification or excuse, and that lawful justification or excuse could also be found in the fact that he was in the horns of a dilemma, obliged to obey the requests of Indicom and obliged to only act through orders coming down his chain of command. These are three principles which we say are incorrect and clearly so. We respectfully commend the minority decision of His Lordship Justice of Appeal Brooks, who on these points identified that none of these matters could provide lawful justification or excuse, supporting the learned parish court judge on that matter. Consistent in both appeals, we say, is the mischief and purpose behind the Indicom Act, which we say is the gateway to understanding the Indicom Act. It's mischief. Indeed, the mischief of the Indicom Act also coincides with reading the statute consistent with Jamaica's international obligations and its constitutional requirement for respect for the right to life. So all of that is wrapped up in all of those keys to statutory interpretation are wrapped up in that duty to observe the right to life and to respect it. And in that regard, the Inter-American Commission of Human Rights decision in Michael Gale and Jamaica is very instructive. It is what led to...
Would you like to articulate what the mischief is?
The mischief is that for a long time, Jamaica had high rates of police-involved killings, and the investigation and prosecution of those killings was not being done in the desirable fashion. There was lack of independence in the investigations and questionable decision-making in the prosecuting of the matters. And we had a situation where...
Well, would you say then that the mischief can be formulated thus, that there should be an independent agency, apart from the traditional public authorities, charged not only with the duty of investigating crime, but also of taking it to its natural destination?
That is it encapsulated. And indeed, in the Michael Gale case, the Inter-American Commission noted the failings in that area and specifically called upon Jamaica to make reforms of the way in which these cases, that is, cases of security force involved killings, were investigated, to cause them to be reformed, both the investigation and the prosecution. The Inter-American Commission called for reform for both.
Right. Well,
we say that to reform the investigation required statutory power and required amendments to the law. And in fact, they did a new statute for that purpose. We say to reform the prosecution, we already had at common law a very democratic prosecution process which allowed everyone access to the courts. So there was no need for statutory conferment of prosecutorial power. It had already been conferred at common law and recognized in the Constitution.
Yes, your position, as I understand it, is that the common law gives a power to prosecute, and you have to find something in the Act to derogate from that power.
Indeed, and it must be explicitly derogated and not impliedly.
Yes.
In the Unison case, the Supreme Court in the UK here made that very point, which I may take your lordships to, but I'm sure your lordships know it quite well. There are some points about the Michael Gale case which your lordships, I would want to take your lordships to. At paragraph 4, the recommendation, it is at volume 2, tab 37. Okay. Oh, page 1389 is the page I'm going to right now.
I'm afraid we don't have tabs, but...
Page 1389, my lord.
Is this written or as electronically?
Electronic, on the electronic bundle.
Because we're always about a page or two apart.
Oh, I see. I think the Michael Gale case starts on my record at 1388.
Yeah.
No, it starts at 1388, but the passage I'm taking my lords to is at 1389.
yes?
At the top of that, that's paragraph 4 being completed. The Inter-American Commission...
so you're reading from which paragraph?
It's paragraph 4, but I'm taking... Yes. The Commission also recommended that the state adopt such legislative or other measures to undertake a thorough and impartial investigation for the purpose of identifying, prosecuting, and punishing. And at the end of that very paragraph, it called for general reform to the procedures for investigating and prosecuting deprivations. This is at a time, my lords, where before a police officer could be charged, the Director of Public Prosecutions was required in practice to rule or to consent to him being charged, although there was no, although it would have created an unequal arrangement where for the same offenses, the ordinary person could be charged without the DPP's consent for the same offenses. The other paragraph I will take your lordships to is paragraphs 83, which is 1407 in the electronic bundle, or 1408.
Add one.
The Inter-American Commission, here relying on UN documents regarding the requirements of an investigation, and particularly the UN principles on...
Forgive me, Mr. Minister, I'm afraid that the copy that I'm working from is the hard copy.
Oh, I'm sorry.
It jumps from paragraph 81 to 174.
We do need paragraph 84 for the point I'm going to make. Your Lordship doesn't have that paragraph.
I don't, I'm afraid. But don't worry, we'll sort it out afterwards.
Does your Lordship have page 1407? Is it saying this?
Which paragraph are you referring to?
Paragraph 84.
84.
Yes, I do have that. Thank you.
I'm about that. So at paragraph 84, they refer to two UN documents, well, a UN document and another guide, the UN principles and the Minnesota Protocol. And then at paragraph 85, they extract approvingly from the UN principles. And your Lordships may see paragraphs 9 and 18 from those principles. And I note, for example, at paragraph 9 of the principles, there shall be thorough, prompt, and impartial investigations. And the next sentence, government shall maintain investigative offices and procedures to undertake such inquiries. And at paragraph 18, the second sentence in paragraph 18, government shall either bring such persons to justice or cooperate to extradite any such person to other countries which exercise jurisdiction. And then at paragraph 86, from the Minnesota Protocol, the leading guide as to how these investigations should be done. One of the most important aspects of a thorough and impartial investigation of an extralegal, arbitrary, and summary execution is the collection and analysis of evidence. It's essential to recover and preserve physical evidence and to interview potential witnesses so circumstances surrounding a suspicious death can be clarified. I stress that because in this case, in the Diah case, what Superintendent Diah did was prevented the independent commission set up by Parliament from doing a proper collection and preservation of physical evidence, because the firearms were there for analysis by the forensic examiner, for him to swab them for DNA, gunpowder residue, and any other such thing that scientists do, and also to put them in a box so that they could be preserved, to be carried to the laboratory in a sealed fashion for further forensic analysis. And what he did was to take those weapons from the forensic person who was to analyze them, barehandedly take them to his vehicle to take them to the lab in a manner which was contrary to the manner in which Indicom, who was in charge of the investigation, wanted them to be treated with. And the other point that I will note to your Lordships is at paragraph 88. Because one thing which must be said in this appeal is that, in both appeals, is that Jamaica has a unique problem when it comes to police-involved shootings. There are few countries in the world that have as high a per capita ratio of police-involved killings. Indeed, the number would be high for countries many times the size of Jamaica. In this, at paragraph 88, which is page 1409, or 10, the Commission took into account information indicating that impunity for killings by the police remains a serious problem in Jamaica. As the petitioners noted in their petition and subsequent submissions, a pattern has been identified in Jamaica whereby a disproportionately large number of killings are associated with the state security force, but where very few prosecutions have been undertaken in relation to those killings. The petitioners indicated that the number shot and killed by the police over the past decade have averaged 140 per year. Jamaica is a country of 2.5 million people. This is a very high ratio, and it is well known that indeed the average increased to well over 200 a year, although now, since the advent of Indicom, it has now fallen to about 100 a year. So Jamaica has had and still has a special problem, which the Commission, the Inter-American Commission, in the last sentence of paragraph 88 said, Jamaica faces a particularly high burden in establishing that its investigations of police killings have been thorough, prompt, and impartial. At paragraph 89, they make particular criticisms of the Michael Gale case. I don't know how much your lordships know the facts of the Michael Gale case, but this is a case where a young man with a mental illness was kicked and beaten and stomped by police and soldiers, and he later died. And the police put what they later admitted to be a trumped-up charge on him. So he was charged with assault. The officer at the coroner's inquest said he agreed it was a trumped-up charge. And he died days later. That is, Mr. Gale died days later. And the inquest did not name anyone as the perpetrator. And the DPP decided not to charge anyone. So at paragraph 89, the Commission made criticisms of the investigation. I'm taking it in the middle of the paragraph to save time. No forensic tests were conducted at the scene. The very thing that was to be done in the Diah case, criticized here. None of the weapons or implements were recovered or examined. A precise complaint being made here, which is again what Mr. Diah, now that we have the Indicom Act, what he continued to cause to happen. No police sketches were made from witnesses' statements, and there were no attempts to form identification parades or lineups. That is quite important, my lords, because the citizen will hardly ever know the name of the officer who is assaulting him. There will need to be some identification procedure or identification by ballistic comparison. One arsenal that a police officer has is that if the citizen doesn't agree to identification parade, he could arrest him and conduct an identification procedure. In fact, the case of Dallison and Caffrey, which my learner from Mr. Small will deal with, explains that. So the criticism here was the police did no lineups for their own officers to present identification evidence to the court. And at paragraph 90, they make the point that these identification failings undermined the case. At paragraph 93, the Commission again returns to the point that these incidents rarely result in prosecution or convictions of the officers involved. That is the fourth line in 93. And that this in turn has led to the perception in Jamaica that the police are above the law and has adversely affected the relationship of trust that should exist between our population and the forces. And at paragraph 94, they say the death should have been conducted from the outset by a body independent of the JCF and the JDF. I pause, my lords. The military in Jamaica routinely assists the police. It does not require martial law or a state of emergency. They routinely, on a daily basis, assist the police, because we do admit that there are serious crime problems which do require the police and military combined role. So they said that there should have been an independent body, independent of both forces, with the authority to fully and effectively investigate both bodies that will result in the criminal prosecution and punishment of those responsible. They then criticized the arrangement that was in place by the Police Public Complaints Authority, an independent body that lacked teeth and did not do an effective investigation, and in fact did no investigation of the Michael Gale case. It was all investigated by the police internal affairs body called the BSI, Bureau of Special Investigations. At paragraph 98, the Commission criticized the decision-making of the DPP. And at 99, I think the point being made at paragraph 99 is, although you could not have identified the individual perpetrator who kicked and stomped, all present could have been liable accessorially or for misconduct in their public office. And the Inter-American Commission said most systems of criminal justice have such liability, and we certainly have it in the Jamaican system. At paragraph 101, with regard to the exercise of the DPP discretion in particular, the state argued that under the Constitution of Jamaica, the DPP has exclusive authority in Jamaica to institute, continue, or terminate. That is, in fact, an incorrect submission that was made to the Inter-American Commission. The DPP in Jamaica does not have exclusive authority to initiate prosecutions. The DPP, under Section 94 of our Constitution, has exclusive authority to take over and terminate other prosecutions instituted and conducted by other persons or authorities. But the DPP has no exclusive authority to initiate prosecutions. Indeed, the DPP in Jamaica hardly ever initiates prosecutions by their own hand. The prosecutions are ordinarily initiated by the police, sometimes on the advice of the DPP. A prosecution in Jamaica is started by laying an information, I suspect, similar to how it is laid here in England. And the information is laid by the informant or prosecutor, typically a policeman, but it could be any citizen, going to a JP and saying, this is the information, and the JP will, having heard that information, sign the information and either issue summons or warrant, as the case may be.
Well, if the police normally initiate prosecutions, what is the incidence of the DPP taking over those prosecutions?
Yes. Well, we have in the summary courts in Jamaica, those prosecutions will almost always not be done by the DPP.
Will be done by the police?
No, we have in Jamaica the clerk of courts. These are persons who are some learned in the law, some not. But nowadays, the majority are learned in the law. Young lawyers who
anyway, don't just get
yes,
into the...
But they report essentially to the Chief Justice. It's a very unusual system. And so for summary cases, the clerks, I would say the vast majority of cases are prosecuted by clerks of court who do the summary courts. Mm-hmm. And then for the indictable matters at the circuit court or assizes, those will be done by the DPP's office. Mm-hmm. Of course, the DPP may take over prosecutions being conducted at the clerk of courts level.
What about the incidence of private prosecutions in Jamaica?
Yes, I must say, over time they have become rare. And indeed, I believe it is the rarity of it which has caused some to believe that only the police can initiate and that these prosecutions must be conducted by the DPP or the clerk of the
Well, on
courts.
those rare occasions that private prosecutions were initiated, does the DPP normally take over, or what is the situation?
No. Indeed, there will be many prosecutions being done at the summary court level, which the DPP will play no part in.
Private prosecution?
Private prosecutions, and indeed also prosecutions initiated by the police being done by the clerk of the courts.
I see.
Where the prosecution's been done by the clerk of the courts, does the clerk become named as the prosecutor in the proceedings, or is he just doing it on behalf of the police?
He's doing it on behalf of the police.
Right,
because the prosecutor will be named as the informant. In the Diah case, the prosecutor...
So that would be the superintendent or chief inspector or whatever?
Yes, so in our case, the prosecutor was named as Dave Lewin, who at the time was an investigator of Indicom.
Yeah, but we're talking about the cases where conventional cases might be the wrong nomenclature, but where the clerk of the courts, as my lord mentions, is taking charge of the prosecution, would the prosecution proceed in the name of the police officer in charge of the case?
Yes.
Yes, I see.
The case will be called the Queen versus, this case was called the Queen against Albert Diah.
I see.
And the information itself, below the Queen, was written informant Dave Lewin, investigator of India.
Yeah, well, we're talking now about cases that are...
Oh, in the other cases,
where the police are...
if I were a policeman, it would be Corporal Terence Williams.
Yes, I see.
Named there. And in fact, on the reverse side, the name of the informant is there very plainly stated.
Mm-hmm.
That this is the reason, this is the person who brought the case.
Right. Okay, let's proceed then.
Yes. And then we, I would just note that the recommendations are formally set out at paragraph 114 of the Michael Gale case. Now, I know that my learned friend has said that in the Michael Gale case, the procedural obligation for an effective investigation was stated there as resultant from the right to a fair trial, etc. But I think it is now beyond doubt that those principles are principles that result from the right to life. And we have, there are the cases such as Ramsahai from the European Court of Human Rights. I would also refer to, we also have in our bundle Jordan and the United Kingdom from the European Court of Human Rights. And there is a very good summary of the law in Halsbury, which you have also included in the bundle.
I'm sorry, where is that?
From Halsbury's.
Yes.
Which is also, Halsbury's, I refer particularly to it's volume 8, tab 144, volume 8, tab 142, and tab 144. I think those are the main references. Yes, I think my learned friend also makes a point in her response that whether the European Court of Human Rights cases can be applied to Jamaica, whether that jurisprudence on the right to life. In other words, that the right to life means a procedural obligation for an effective independent investigation, an investigation which has the means to, in an appropriate case, lead to access to the courts, etc. I would answer it in two ways. The first is that the right to life is a universal concept, and it could hardly mean something different, certainly in England, as opposed to Jamaica. And I would think it could hardly make a difference, mean anything different in the Western democracies, for that matter. Indeed, it should mean the same thing worldwide. And the second thing is that the board has previously said that European Court of Human Rights cases are applicable to Jamaica. because Jamaica was a signatory, I'm not fair to say signatory. The convention was extended to Jamaica before our independence, and the Jamaican Constitution is modeled from the principles of the common law and from the European Convention on Human Rights. I would refer to the Grant case, where the board said that at paragraph 17 of Grant, which is at volume 3, tab 79.
Page?
Page. I'm sorry, I don't have the page. I'll find a page for you. Volume 3, tab 79 for Grant. It's paragraph 17. So, 2509 for Grant of the electronic bundle. So,
well, I presume you would like to argue that, quite apart from the question of whether the European Convention on Human Rights has any direct application to Jamaica, the jurisprudence that the right to life under Article 2 of the Convention has spawned is nevertheless a useful source material in order to decide whether or not that, as you put it, that universal right should find expression in a proper independent investigation of crimes involving the killing by state agencies of individuals.
Indeed. And also, Jamaica is certainly a member of the Inter-American Commission, which is why we are signatory to the American Convention of Human Rights, which I believe is in fact even older than the international convention. And Jamaica is a signatory to that. And based on the Michael Gale case, there was an international law obligation to conduct, to cause there to be an agency that could conduct investigations consistent with the Commission's interpretation of the state's obligation in Michael Gale.
Right.
So therefore, we have the Michael Gale case, and this led to the formation of INDECOM within a few years of the case. So we make these points regarding the procedural obligation. The first point is that fostering, safeguarding, and securing the right to life must be the first function of INDECOM. So before we even take up the INDECOM Act, we must recognize that, of course, all, as your Lordship said in the Jamaicans for Justice and Police Service Commission case, although all state agencies are obliged to foster further, safeguard, and secure fundamental rights, we all are, but that this independent commission has a special interest in fostering and safeguarding right to life and other such abuses by ensuring compliance with the procedural obligation. So INDECOM, the commission, the independent commission, has that duty, first of all, to comply with the procedural obligation, which would include they must be independent, they must be effective, and they must be able to put appropriate cases before the court for adjudication.
Well, that sets the scene.
Yes.
Shall we move to the nitty-gritty of the provisions?
Yes. The other point is, of course, effectiveness and independence. And I will move now from the procedural obligation, and I will turn next to the INDECOM Act and to, and I will take you to the provisions which are relevant to the case against Mr. Diah.
The INDECOM Act is tab 8, is that right?
It's tab 8 in
Which
page
is 912.
912.
Yes.
912.
912.
Thank you.
The act was passed in April 2010 and came into effect in August of that year.
Yes.
Section 5 of the Act, I will just take you through it well, let me take it Section 4 first, if I'm going to take it through it that way. Section 4 of the Act says, 4.1a gives the power to conduct investigations. At 4.2a, I will note, my lords, that the Act specifically says including any weapons. The Act could have been written by just saying all report or all evidence related to a scene or an incident, but the Act specifically said including any weapons. I make that point because Mr. Diah, the respondent, makes the point that the Commission could not possess police weapons. And but yet it is specifically saying including any weapons.
Well, is it significant that they shall have access to weapons?
Yes.
Without necessarily taking them into their custody?
Well, the access to the weapon, well, certainly there would not be long-term custody, but access to the weapon would require, for the purpose of examination, would require some possession of the weapon for a period of time to swab, take down numbers, etc., etc.
Yes, I see. Right.
4.2d, take charge of and preserve the scene of any incident. So it makes it clear who is in charge of these incident scenes. Subsection 3 speaks to some things that require a warrant, but none of the things that were relative to this case required a warrant. I make that point because another of the respondents' claims was he wasn't sure if we needed a warrant, if the appellant needed a warrant. But the things there that are said to require a warrant are not applicable to this case. Subsection 4 of 4. The Commission shall have the power to require any person to furnish in any manner and at such times as may be specified information, etc., etc.
Subsection 3b may be relevant. The Commission is entitled to retain property.
Yes, but I just made the point that that is not under the requirement for a warrant. The warrant is under A.
No, I understand that.
Yeah, I see. Oh, I'm sorry. I thought you.
My Lord's point, I think, is important in that
Yes.
in the course of the investigation, it's entitled to retain property.
Yes. Yes.
So long as its retention is reasonably necessary for the purpose of
I'm obliged to my Lord. It's indeed.
which
Because another point that. That
may actually be an answer to my question
Yes.
as to whether or not
Yes.
you're entitled to retain the weapons.
I'm obliged. Because indeed, another.
And if you can show that the retention of the weapons for further examination is necessary, well then, prima facie, you can argue that the retention is warranted under subsection 4. I'm sorry, is it subsection 3 or subsection 4?
Subsection 4.2a. 4.2a.
No, 4.2b, I think.
Weapons? 4.2a.
3b. 3b is...
yeah, 3b.
3b. Oh, I'm sorry. I am with you now. Yes.
Yeah.
As regards retaining. Yes.
Right.
Section 5 states the independence of the Commission. There's a point that I need to make now, which will be of much use later, but I'll make it now just to save time. Your Worship will note that subsection 5.1 says, the Commission shall not be subject to the direction or control of any other person, or authority. I'm saying this is indicative that a commission is in fact a person or authority by the use of the word other.
Which subsection is that, sir?
5.1. Any other person or authority. Indeed, if I could just go back a bit, since I'm there on this point, if your lordships will look at section 3.2 of the Act. It says the commission shall consist of a commissioner. So the commission is personified in the commissioner. We make this point because it was the decision of the Court of Appeal was that the commission had no personality. But the commission is the commissioner. So I have shown you section 5 for independence. Very important independence point, because the point being made by Justice of Appeal Phillips, agreed with by the others, was that in the Diah case, the commission needed to have the agreement of the police high command for all of these investigative steps, which would certainly be contrary to independence in the statute and independence required by the procedural obligation. I'll move quickly forward to section 21. My Lord Brooks at the Court of Appeal relied heavily on this section in his dissent. The commission in this section is being given Commission of Inquiry powers, which is not a requirement of the Minnesota Protocol, to get to all the evidence in a matter. So it says at subsection 1, it may at any time require any member of security forces to furnish, or any other person who is able to give assistance, to furnish a statement of such information and produce any document or thing in connection with that investigation. And 21.4 says he has the power of a judge of the Supreme Court in regards to the production. And it says that at subsection 5, he cannot be required to produce anything that he would not be compelled to produce in any court of law. So that would be the lawful justification or excuse not to provide the weapons. It would be, a court could not compel me. And of course, a court could compel him, so he would have no lawful justification or excuse. At section 22, it says, the commission, I'm going down 3 lines for brevity, may issue directions to the Commissioner of Police or any other authority for the purpose of this section. Now, it doesn't say issue written directions. It says issue directions to the Commissioner of Police or any other authority. And it says, it begins by saying, notwithstanding anything to the contrary in any other law. Is how it begins, that subsection 1 of 22.
You say that is relevant to the idea of there being a conflict because
Indeed.
You say that this prevails over it.
Indeed.
Yes.
Indeed.
But all of these provisions speak to the powers of investigation of the Commission,
Yes.
not to the powers to institute prosecution.
I intend to come to those
Right.
After Mrs. Wellington has finished it.
Right.
That's the vision.
Well, it certainly sets the background that the Commission has extensive powers in relation to investigation.
Yes.
So no doubt we'll hear that married up to your argument that it must have powers to prosecute as well.
But I will deal extensively with those shortly, because what we do say as regards the power to prosecute is that because of our special interest in these matters, and because we are following the constitutional obligation, and because we have taken from the police an area that was once theirs, that is, investigating their own for potential abuses. That having taken that from the police, we then have the with the common law right to prosecute. This falls within our remit because we have the special interest in the area.
Well, now you say taken from the police. I mean, are the police excluded from conducting investigations into such matters as the Commission has the power to investigate?
No.
No. So it's a concomitant
Indeed.
power to investigate, right?
But I would think, because there is a supervisory power under the Act where the Commission can supervise the investigations being done by the police.
Yeah.
But I would think that with the obligation to observe the right to life, it would be a rare case that for any serious abuse, that should be left to the police to investigate. It would mean no change.
Because of the requirement that there be an independent
Indeed, and
element to
it
the
has own peculiar problems.
Right, well, let's move on then.
Yes, so 22.2 limits the police role on the scene. Their role on the scene is to attend the scene and preserve until the arrival of the investigator from Indicom. And thereafter, continue to preserve the scene while the Indicom investigator is doing their work. So the role of the police at these scenes have been changed. The other point that I will...
So you say there that there may be a concomitant power of investigation, but as far as the scene of the incident is concerned, the police have to cooperate and leave the scene untouched until your investigator looks at it. So there may be concomitant, but there's a hierarchy of authority.
Indeed, because having said this, at 22.1, it says primary responsibility. So Indicom has primacy at these scenes. And it is said twice in the Act, because at 4, I believe it was 4, which was it 4.4, which I referred to earlier. It says, no, it wasn't 4.4. It was take charge and preserve was 4.2d. So the legislature, the Parliament, has said it twice in this statute. At 4.2d it says take charge and preserve is the function of Indicom, and then at 22 they come back to it and speak to these directions.
Right.
At paragraph 26, I make note that the 26.1, the function of the Commission may be performed by any member of its staff or by any other person, not be a member of security forces. Security forces means police and the JDF. Specified official there means the prison service. Authorized for that purpose by the Commission. So where in 21 and 22 we see the Commission may require evidence to be produced, and the Commission may issue directions under 22. 26 is telling us that this may be performed by any member of its staff. I would like to take you to the judgment of Madam Justice Phillips, J.A., which I think, as regards how the Diah matter was, it's page 366 in the electronic bundle.
I'm so sorry, can you repeat that again?
366.
366.
366. It's the Record of Proceedings, Volume 1. Madam Justice Phillips is giving the leading judgment for the majority here. And what she's doing here is summing up her reasons before she completes her judgment. I would pick it up from 104. Of significance in this case, however, the learned parish court judge failed to give adequate consideration of Mr. Diah's defense to ascertain whether he indeed had lawful justification excuse. She did not identify or highlight any evidence that was favorable from which she could accept or reject that he had a lawful justification excuse. She examined the defense as one of mistake of law or fact, when he was in fact saying that he, being uncertain as to how to proceed, had been following the orders of his superior. That's the superior orders. As indicated, police force orders are supported by the Constitution, the Police Service Regulations, and the Constabulary Force Act. The fact the prosecution's evidence was that there was no force orders existent at the time of the incident governing police firearms, in my view, clearly cumulatively amounted to a lawful justification excuse for failing to comply with a lawful requirement of INDICOM, and therefore by its actions not obstructing INDICOM in the performance of its function. So she's saying superior orders, it not being in the force order, so it's superior orders on the ground, it not being in the police orders before would be sufficient to form lawful justification or excuse. 105. I've noticed that my learned brother, Brooks, J.A., in paragraph, right, of his judgment, referred to Mr. Diah as being absolutely wrong in his approach, and that had he been less arrogant in his approach, he might have been charged. However, although perhaps regrettably in too forceful a manner, I viewed Mr. Diah's behavior as resisting the requirement made of him by Mr. Campbell. He was faced with a genuine dilemma, which had been brought about by the dichotomy of competing instruments of legislation. And one wonders if Parliament had given a comprehensive and thorough analysis of the situation as is required and is expected. Although Section 20 of the Act speaks to INDICOM's Commissioner having primary responsibility for the preservation of the scene of an incident, I pause. It doesn't speak to INDICOM's Commissioner. It speaks to the Commission, which is a very important distinction. The Commissioner cannot be at every scene of an incident or alleged incident, and states he may issue directions. And it doesn't, again, it's not he, it's the Commission may issue directions to the Commissioner of Police or any other authority for that purpose of the section. And the exercise of that responsibility is stated to be notwithstanding anything to the contrary in any other law. The binding force of the force orders on police officers pursuant to the police service regulations embraced by the Constitution is designed to result in difficulties. So the dilemma, according to Madam Justice Phillips, is between the law and the orders made by the police commissioner.
Your short point is that Section 22 gives the answer.
It trumps it. And that clearly was its intention. It is therefore crucial and of great importance that INDICOM's Commissioner and the Commissioner of Police establish protocols as to the preservation of the scene of an incident. And in static sense, it's advisable that the directions referred to Section 20 that must be issued timely. So what, at 106, Madam Justice Phillips is saying, where the Act says the Commission must issue directions, what must really happen is that the Commissioner and the Commissioner of Police must agree protocols, which is inconsistent with an independent investigation, inconsistent with the statute. 107. In my opinion, given the entire scheme of the Act, that the Commissioner and his staff are to report matters on offence to the DPP, I find it difficult to accept, and a proper construction of the words stated in Section 22 of the Act, that Section 20 could have meant that any INDICOM personnel could give direction to, say, the Commissioner of Police. But why not? If the Commissioner of Police had valuable evidence, why couldn't the statute speaks in a fulsome way that the Commission's powers are exercised by any member of the Commission. So why, if the Commissioner of Police or a senior officer like a superintendent like Mr. Diah had valuable evidence, why should he be immune from instructions of the Commission?
Well, expressed in another way, the whole purpose of the legislation, you say, is to establish the independence of the Commission and to compromise that by requiring the Commission to agree protocols with the police as to how that should be carried out, compromises the independence of the Commission.
Indeed. And in a practical sense, would make it unworkable on the ground. I know your Lordships would have read the papers, and the feature of the case was there was a change in procedures, that the Commission had started to require that the guns be boxed, all guns be boxed, to preserve their integrity for further scientific examination. And the point that was made was, oh, we didn't know that you were boxing guns. But the point is, you did not need to know. There was no need for the Commission to announce beforehand that we are going to be now boxing the guns. And indeed, this is what the parish court judge said in her reasons, that if the Commission has a new investigative technique that it is using, which is a lawful technique, there is no need for the Commission to make the police, give the police notice, in the same way that the police would not give notice of their investigative techniques to the general public, in case those investigative
Well, I think another way of putting that is, if the Commission came under scrutiny for its independence, submitting to protocols agreed with the police might well be regarded as compromising that independence. It was necessary for them to establish their own procedures and to cleave to those, irrespective of the impact that that might have upon the conventional operation of police procedures. Right, let's move on then.
Yes, I would just want to take you to the Millicent Forbes case, a decision of the board. I have it as page 2448, volume 5, tab 75. This is page 2448.
2448.
Yes, 2448.
Thank you.
Or 49.
Yes, probably.
Paragraph, this is a case where a young girl was shot and killed by a policeman, and the trial failed for a variety of reasons. It came to the board on the issue as to whether the acquittal could have been quashed. But I bring it to your Lordship's attention to show, first at paragraph 2, the importance of ballistic evidence in these cases. Because paragraph 2, the main evidence against Mr. Allen, the policeman, the policeman was Allen and the deceased was also Allen.
Well, you say this is 2448, is that right?
It's 2449.
2449.
But paragraph 2 is on 245 there.
Yes. The paragraph, I believe, is on 2450.
Yeah.
Yes?
Yes, this is paragraph 2. It shows the fact that the main evidence to identify Allen as the shooter was going to be forensic evidence, that the bullet had been fired from a particular gun. And they were going to prove that Allen had this gun by production of the firearm register. But that register was destroyed in a fire. And then they were going to bring the detective sergeant to whom the statement had been made that the man, Allen, had the gun. But the court was told that that the detective sergeant was overseas and not likely to return. But that was false. It led to the court offering no evidence and the officer being freed. I just make this point because it does two things. It shows the importance of ballistic identification in these police cases. And the kind of weapon in the case of Mr. Diah was an M16, where one can easily move its parts and dismantle it, and ballistic identification will be made not, which is why sealing it in a box is important to make sure that nobody can tamper with it. And the second thing is, it is things like this which happen in cases where the police have control of the prosecution, that they're able to give false information to the courts, which lead to their colleagues being acquitted, and in this case, irreparably acquitted. Well, so the first proposition then of that we must answer is the majority correct that the police are in some special position as regards civilian or civil law, in that they must only take commands that come through their hierarchy, their chain of command. Is there something in service law that requires this? We say the answer is clearly no. Service law, as mentioned in the Constitution, its only meaningful mention in the Constitution is that 16.9 of the Jamaica Constitution, 16 sub 9 of the Jamaica Constitution, where it says that the double jeopardy principles do not apply to a service law acquittal or conviction, and that they may still face civilian law even though they have been acquitted or convicted in a service law hearing. So if anything, that service law provision is showing the strength of the civil law over the police and military. I've already noted that the law says primacy and uses the word notwithstanding, and I need not repeat that. The other point I would make is, if it were that the police were not subject to the civilian law, that would certainly contradict the very principles of equal treatment in our Constitution. And it would mean a complete failure of the independent and effective investigation. Indeed, if one looks at the history of the constable was always under, or started off being under the command of the justices of the peace. And indeed, they formed themselves into police forces much later on. But even when they did, under reforms made by Sir Robert Peel, the principles, and I refer particularly to the 9 Peelian principles of policing. The 7th says, the police are the public, and the public are the police. The police being only members of the public who are paid to give full-time attention to duties which are incumbent on every citizen. That is number 7 of the Peelian principles, which, and the Peelian principles are in volume 8, tab 133.
Thank you very much.
I know they are well known, although I don't know whether they are really ascribed to Sir Robert Peel.
I'm not so sure whether an historical excursus is going to assist us as to contemporary standards. And I could, I do have a...
I have the Peelian page, please.
The page, 3605.
Thank you.
Well, we do have references from Diah, which is somewhat historical. For this point, I would... they follow next in the tab, so they are volume 8, tab 134, and there are 2 references to Diah that, speaking about soldiers, that they still remain subject to the law, page 193 to 194, and page 300 to 301 cover that.
Right.
But a more modern reference, my lord, is Lord Bingham in Queen and Spare, in the Supreme Court, in the Supreme Court in 2003, which is at volume 7, tab 112.
Set out in your case.
Yes, and we take in our case we extract the relevant paragraph. It's page 3177 for Spare, and Lord Bingham says, a man does not, by becoming a soldier, cease to be a citizen. On becoming a soldier, he subjects himself to duties and to risk of penalties to which a civilian is not subject or exposed. But he remains subject to almost every law, including the criminal law which binds other citizens. More historically, we have Burnett and Abbott with Lord Mansfield saying similar things, saying that soldiers need not to await their commander's orders to act as any civilian would. And Burnett and Abbott is at volume 4, tab 63. I'll shortly give you a page. 2171. It could be 2172 in the electronic bundle. And I would say, my lord, that in a more modern way, Burton Abbott has been applied in Fiji in 2010. And
I don't think there can be room for much debate about soldiers and police officers being amenable to the law just in the same way as every citizen must be.
Indeed.
The real issue here is the extent of the Commission's remit, whether it extends to not only investigating offences and the powers that are necessarily complementary to a proper investigation, but whether it extends to actually instituting and conducting a prosecution. I mean, that seems to be the central issue, isn't it?
But that is the second half, because that issue did not cause Mr. Diah's acquittal.
Yeah.
Indeed, his acquittal was on the basis that I read from Justice Phillips's decision.
Yes.
The view that the laws conflicted and he was in a dilemma. We were saying he was in no dilemma. He was obliged to obey the directions and instructions given to him by the Indicom official.
Yes, so as I see it, on the first three defences, the first half of your case, the short point is the police, like every other citizen, are subject to the law, and Section 22 of the Act gives the answer.
Indeed. And 21 with it as well.
Yes.
Yes, indeed. I would only finally, because it came to us by extensive research, I would want to refer to Trepanier and Beek from the Canadian court, where they have a quotation from Emperor Napoleon, agreeing with what Lord Mansfield and...
I suppose that particular historical allusion is irresistible.
I could not read the French, I don't speak French, but in Trepanier and Beek, which is volume 8, tab 123, in the Canadian, I think it's their court-martial appeals court, he says, there is one justice in, I'm sorry, tab 123.
Which is 13458.
At paragraph 21 of Trepanier, he says, Napoleon said, there is one justice in France. One is a French citizen before being a soldier. And I would say the same for in our situation here. We have also dealt with the assertion that Indicom's investigative techniques must be published beforehand. It is set out in our case at paragraphs 31 and 32, and I would not trouble my lords to, because they're so related, I won't trouble my lords to deal with it. There was a point being made as to whether the Indicom persons could possess the firearms. That Mr. Diah could have been mistaken in the view that Indicom officials could not have custody of police firearms. I must say, factually, it's a bit of a strange defense, because his argument was the change was the boxing, was putting it in a box. So before, they had possessed them and swabbed them and examined them, but what is different now is that they're going into a box and being sealed. So it's a rather strange thing for him to be saying, I doubted whether Indicom had authority to possess the firearms. But in our case, at paragraphs 19 to 21, we deal with the issue of the lawfulness of Indicom's officials to possess the firearms. And I don't think it's being doubted. It was not doubted by the Court of Appeal, and my learned friend's response doesn't doubt it, but I just make it out for the purpose of completeness. The other point that is made by the respondent is that somehow the directions that were issued in writing permitted Mr. Diah to act as he did. And these were directions that were issued in February 2013. Yes. This is in the volume 1 record, page 102 of the electronic bundle, page 102.
Yes?
Yes. It is
This is the one that was in force at the time, is it?
Yes, but Mr. Diah said he didn't know anything about it.
No, but it was in force at the time.
It was in force, yes. Mr. Diah, it was not yet in force order. Mr. Diah said he didn't know anything about it. But at this stage, on Mr. Diah's behalf, it is being said that relying on this, his actions were lawful. That relying on these directions, I understand my learned friends to be saying that relying on these directions, Mr. Diah's actions were lawful.
I see.
So it's somewhat inconsistent, given that he was saying he didn't know of them. But we're making what our submissions are, that nothing in these directions could have made his actions lawful.
What's the date of this?
It's February 2013.
Thank you.
If you go to the end of it, February 2nd, 2013.
Thank you very much.
And our incident is in later that year, August. I will just begin at, if your lordship will see that there are some bold numbers in the top right-hand corner, which I think was the original numbering by the magistrate.
Yes?
So 97 in those numberings, this is the preamble, last 4 lines, that these directions are made without prejudice to the rights and obligations under the law. Then we go to page 10, at the top numbering. This is response to an incident scene. Because necessarily the police will be at the scene.
I think it actually might be page 100. Yeah. Well, not to worry. What are you referring us to?
Let me just say the section. Yes, it's section 4, subsection 3.
So it's 10.3.
Yes, 10.3.
It's 103 probably, yes.
Oh, that's what it is. Oh, yes, yes. 100. Right. So it says, 4.1, investigators shall have primary control. But let us go down to subsection 3. Upon arrival at incident scene, an investigator, which means the INDECOM investigator, shall assume control of the scene, all evidence and witnesses, and may issue instructions to any member of the JCF attending the scene.
I'm sorry, what's the point that's being made?
My learned friend makes a submission that somehow these directions permitted Mr. Diah to act as he did. In other words, refusing to have the weapons boxed and sealed and keeping possession of them. And I'm just saying it is a startling submission because nothing in this could be read that way. And I'm sorry to have to take you through it, but it is.
That's all right.
Yes. Then if we flip the page, there are the requirements of the senior responding officer. And Mr. Diah may well have been the senior responding officer.
Yes?
So if we go to Romans 6, he must fulfill or ensure the fulfillment of the instruction of the investigator having control of the incident scene. 7, he must confiscate and label the firearms of all members present at the scene in accordance with the directions set out at section 11 herein. And then we go to, I go over now to page 107, which is 8 sub 2. The senior responding officer shall surrender or ensure the surrender to the investigator of any physical evidence collected at incident scene, including, but not limited to, any weapon of offense. And any weapon of offense is defined any instrument designed or used to inflict harm, but not limited to a firearm, bullet, baton, boot, or knife. And then at page 111, wherever the JCF has recovered any item from any incident scene before, during, after the completion of the INDECOM's examination, the member shall immediately advise INDECOM of the existence of the item and shall take all necessary steps to surrender the item to INDECOM while preserving the chain of custody and the integrity of the evidence. And then, most importantly, confiscation, labeling, and storing, 113. Any weapon of offense suspected to have been used during an incident shall be confiscated by the senior responding officer. Such confiscation shall be done immediately upon arrival at the incident scene. 2, in a manner that preserves the integrity. And 4, in accordance with procedures as may from time to time be published by INDECOM. B, where a weapon is confiscated by a senior responding officer, said senior responding officer shall cause it to be sealed in the presence of INDECOM's investigator or forensic examiner. And then we go down to E. The senior responding officer or investigator shall exercise all due care and skill in handling and storing the weapon seized and shall ensure the weapon is individually tagged, sealed, and packaged in the manner prescribed by INDECOM. So I made that point. That we can see no support for that submission. I move on to the...
Sorry, so you say there's nothing in here which gives rise to any doubt or could give rise to any doubt?
No rise to any doubt, and certainly nothing that could give rise to lawful justification or excuse.
The essential case is, so far from giving Mr. Diah some exemption from INDECOM's writ, so to speak, all of these provisions reinforce the extent of their powers and the requirement that he, in common with all others associated with the case, submit to the exercise of those powers.
That is so, madam.
And 13.2b is directly in point, that the weapon, the responding officer was to cause the weapon to be sealed.
Indeed.
Right.
Superior orders is the next issue. I think it's a well-settled principle that superior orders do not provide a defense at common law. And indeed, in some textbooks, there is not even a section anymore on superior orders. But how did it arise in this case? It arose because Mr. Diah says he called as a witness Superintendent Pinnock, who would have been his senior in command. And Mr. Pinnock said, I said to Mr. Diah, make sure the weapons are taken to the lab. Now, the truth is, that was not inconsistent with INDECOM's request. INDECOM's request was merely that they be boxed and sealed to be taken to the lab. And your Lordship will note that Mr. Pinnock, Superintendent Pinnock, was not cross-examined by the prosecuting counsel because he was saying nothing different to what we had intended. The weapons were to be boxed and sent to the lab. So the superior orders issue is really factually did not arise. And indeed, the learned magistrate, the learned parish court judge, said that it was clear, and she found, that the weapons were going to be returned in the boxed and sealed fashion for taking to the lab. I say that because your Lordships may note that Justice of Appeal Frank Williams added another issue. He was saying that there was a shortage of weapons at that police station. And he added that as another reason why Mr. Diah could have had a lawful excuse. But the parish court judge dealt with that by saying these weapons, the work of INDECOM was not going to delay appreciably the taking of the firearms to the lab.
So, Mr. Williams, I'm not sure I understand this. Your point is there's no conflict between the order given by Superintendent Pinnock, because he simply said, take the guns to the lab. Didn't say anything about sealing or putting them in boxes or anything. Right.
And indeed, there isn't even any indication that he was aware of the resistance or the conundrum that was taking place then. So there was no... But in any event, let us suppose for argument that we could read Mr. Superintendent Pinnock's instructions as a contrary order. The argument made by Madam Justice Phillips and Mr. Justice Frank Williams was that this is the dilemma he's in. Disobeying an order from his superior, disobeying a request from Indicom. It's the dilemma. So our first answer is no dilemma. But the second answer is, if Superintendent Pinnock knew of the request made by Indicom and instructed him to disobey it, that would be an unlawful order that he would be giving to Mr. Diah. And Mr. Diah would not be obliged to obey an unlawful order.
Well, to the contrary, he would be obliged not to obey it, surely.
Indeed.
Right, well, I think we probably have a sufficient grasp of the issues in relation to the extent of the powers of Indicom. But we're still eagerly anticipating
the prosecution point.
Yes.
I think I will just. There's one major topic which my learned friend relies on in their summit, which is the mistake topic, which I'm going to come to next. I would just say that we do have substantial authorities on the superior orders point in our case that we have referred to, but it is surprising that the issue would even come up. Okay, the mistake issue. I will take you to the statements of facts and issues because they are nicely set out there. These were identified by Mr. Justice Brooks as mistakes of law and not fact. And as I understand the respondent, they're saying that they were indeed mistakes of fact. They are saying they're mistakes of fact, we're saying they're mistakes of law. At paragraph 2.8, it is page 716 in the electronic bundle. The reasons Mr. Diah uttered to the Indicom personnel are there set out. So we have them listed. A, he would not permit any civilian to handle police firearms. So that's the lawfulness of a civilian handling a police firearm. It's a question of law. B, he was investigating a crime while Indicom were investigating an incident. And his investigation took precedence over Indicom's investigation. C, he could not be instructed by Indicom personnel as he is a policeman. Mistake of law again, we say. And he did not wish to hear about Indicom's guidelines. Then, in his unsworn statement, which is at page 718 of the electronic bundle, he says,
page
718.
718.
He says, although he is aware that section 4 of the Act authorized Indicom to have access to weapons, he was unclear of what access meant, whether a warrant was required, the duration of such access, and who should have access. These are all his troubles interpreting section 4. B, he was not sure whether handing weapons to Indicom breached the Firearms Act. So that is his legal troubles with the Firearms Act. As he was in charge of the operation, he made the decisions. Next one was, based on his investigative experience, Indicom didn't need to process the police weapons. It's a challenge to independence. He was not entertaining the Indicom investigator, meaning that he was not listening to him. He could not give him instructions. So he didn't think the Indicom investigator could give him any instructions. So he doesn't understand section 21 of the Act. And then he says, at F, the superior orders point is uttered by him. And then he says he has always cooperated with Indicom. It's very important, my lords, that the distinction between fact and law, mistakes of fact and law, be clearly stated. And I would refer particularly to two main authorities on this. The first is the Philip Reed case, which is at page, it seems like 3235, volume 7, tab 113.
3235.
I think so. My handwriting is correct.
Sorry, which tab?
It is tab 113.
Thank you.
Oh, I'm sorry, it's 3230? Okay. Well, it's 3230 or 3229, but I think the page I'm going to is at 3235, which is page 1289 of the judgment. Of the judgment.
1289, yeah.
Yes, 1289 is 3236. At least it is in my electronic.
Yes, it is.
Oh, yeah.
Right, well, what does this tell us?
Is this the case whether the man's refusal to provide a specimen for testing under the Road Safety Act was with reasonable excuse, because he had a mistaken view of the law that he was not obliged to give the sample. So as I'll take it up at paragraph D of the judgment. This is a judgment of Lord Justice Carmel. As I indicated in argument, I have some sympathy with a man who acted out the part of the street side Hamden. I must say, I reading it in context, I understand street side Hamden, but I'm not sure what it really means. But
Yes,
I understand in context.
Let's be distracted by street side Hampton.
When I researched Hamden, it came up Hamden Park, and I didn't know what it really meant.
Yeah.
The ship money case of the early 17th century, when he took on the executive, the government of Charles I.
Oh, I see. All
So
right.
John Hampden is a civil rights hero of that period.
Oh, okay. Well, I was completely off. I thought it meant a court. I also with a man who acted the part of a street side Hamden on a view of the law which is ultimately found wrong, but which has indeed caused a great number of distinguished lawyers a great deal of difficulty. Although I don't think these points in this case would cause any lawyers a great deal of difficulty. But if you choose at a street side to act out the part of Hamden, you have got to be right.
Yes.
There is a Latin aphorism, ignorantia juris non excusat. And although those are words which are variously translated and variously applied in our law, they are remarkably applicable to someone who chooses to act in a challenging way towards a police officer in the street.
Well, I think this is pretty trite law, isn't it, Mr. Williams? I mean, your point is that if he was misconceived about the effect of the law, that doesn't excuse the actions that he took.
Yes.
Yeah.
Indeed, I believe in one of these cases, I think it is the Bentley, Lord, or was it Blackburn and Boring? Lord Bingham said, the mistake cannot be as to the capacity of the person. In other words, if I can put it in a simpler language, if Mr. Diah's mistake was that he did not know that these persons were Indicom investigators, that would have been a mistake of fact.
Right.
But a mistake as to the capacity or powers of the Indicom investigators is a mistake of law. And it is made out in the Lee case, referring to Bentley and Blackburn and Boring. I've also included Hewitt.
And the reference to Bentley?
Bentley is it's an old case. It's 1854 Cox, but it's referred to in Lee. So we take it from Lee, which is at volume 3, tab 43.
Thank you.
Page.
Oh, I'm sorry, page. And on this point, 1703 for Lee, which is now the leading case on resisting and so on, arrest and so forth. We are also included Hewitt, which is at volume 5, tab 81. I think that's page 2540. Hewitt, which applies Lee. It's a case where the man was arrested and didn't know the police had the power to arrest him. I think he broke a window.
But the key principle is set out in your case at paragraph 41 from Bentley.
Indeed.
Namely, the rule is that no man shall be excused for an unlawful act from his ignorance of the law.
Yes, yes. And the other thing I would add to it is there's a Canadian case from the Canadian Supreme Court, MacDonald, which is at volume 6, tab 99. And
2914.
MacDonald?
Yeah. 2914.
Yes. In the MacDonald case, it was whether the firearm license permitted him to have the possession of the gun in some places, but not in others. And he claimed to be mistaken as to where he could and could not. And they said that erroneous subjective belief on law is...
Well, I think that point is probably sufficiently well made now.
I have well made that now, so I will finish it. Well then, I think I am finished with the points that I would like to make as regards his acquittal. My learned friend, Mrs. Taylor Wellington, will make a point as regards the sentence, and then I will pick up back again on the prosecution point.
Thank you very much. Mrs. Taylor Wellington.
May it please you, Your Lordships. My time here is brief as my task is small. The issue that I'm about to address regards the disposal of the appeal. In particular, it is pleaded by the appellants in this matter that the decision of the JMCA, the Court of Appeal, be quashed and the orders in respect of the conviction and the sentencing be restored. However, the respondent has made an alternative submission, which I wish to address, in that they seek that should the appeal be allowed, as we pray, that the matter ought to be remitted to the Court of Appeal for the issue of sentencing to be considered.
Yes.
Our submissions on this matter are twofold. The first is that, well, we disagree with that submission and believe that the issue of sentencing has already been properly ventilated by the Court of Appeal, and therefore remitting would serve no useful purpose. And secondly, if you do believe it was not, if your lordships believe that it was not sufficiently dealt with, then it is something that falls within the remit of this court, and therefore, again, it would serve no purpose to have the matter remitted.
So we'd say that we should determine what the appropriate sentence should be.
If it is that you are of the view that the issue of sentencing was not properly ventilated by the court of the JMCA, then it is within your remit to consider that issue, and it would save cost and time. We wouldn't need to have that matter remitted.
It is not the normal practice of the board, I think, to rule on sentencing matters if a sentence is overruled.
Indeed, it is not the normal practice of the board, but there is precedent in Ramdean against the state of Trinidad and Tobago, where it was actually considered, it was deemed within the remit of the board, though it is, as you said, not the normal practice. But to quickly point you to the sections of the JMCA's decision where it was considered, we will go to all three judges we submit unanimously agreed that the sentence was not manifestly excessive, as was claimed. Despite the fact that, Madam Justice Phillips, Justice of Appeal, indicated that she would not go into much reasons for it, she did outrightly say that it is her view that the sentence was not excessive, and that can be found at page 364 of the record. Paragraph 101.
Thank you.
And Mr. Justice Brooks, J.A., went in more detail, given his finding, of course, that the appeal ought not to be allowed. he went into greater detail. He found that it was not manifestly excessive. He said that the parish court judge's reasons were, and her judgment was beyond criticism. Those are the words that he used. And he, in considering the issue of sentencing, he looked at the fact that given that the Indicum Act was very new, that we do not have a lot of precedent in respect of sentencing under this particular provision. But he considered the rationale for the offense for which the respondent was charged and his good character. So he considered all of these factors. And he also considered the fact that the maximum fine was 3 million Jamaican dollars, and all that was Mr. Diah was fined was $400,000 on each count. And in those circumstances, he found that it was not, of course, excessive in any way. And just as for the information of the board, there is one other case in Jamaica where we have had a conviction under the said section 33 of the Indicum Act, and the circumstances were not as aggravating. However, the fine that was applied was $600,000 for reference. And he went on to say, and again, Mr. Justice Williams agreed with Mr. Brooks in this regard. So all three judges found that it was not manifestly excessive and that it was dealt with. All right, and if I could be, again, if there's any assistance in Ramdean, which can be found at tab 106 of your bundle, page 3102, which will highlight that it's within your remit if it's so needed for you to reconsider that issue of sentencing.
I think there was a further point considered by Justice Brooks as to whether this should be recorded as a conviction against Mr. Diah or not.
There was an
And he
issue
said that was within the discretion of the
parish court judge. That is exactly what he found. I'm grateful to your lordship.
Yes, thank you.
That could be of no further assistance to the bench.
Thank you very much indeed.
Thank
The only thing I'd add to that is that the exchange rate, I know the saying 600,000 and 400,000 Jamaican dollars may sound like a lot of money.
But my Lord Hodge is an expert on
I think it's
currency converters. So you can rely on him to keep us up to speed on
the
that.
pound to the Jamaican dollar is 180 to 1.
Right, thank you very much.
It's not a, well, it depends on your pocket, but it's not a sum of money as it would seem.
It looked awfully large at first sight.
Yeah.
Yes.
But
I'm sorry, sir?
it looked very large at first.
At first, yes, indeed.
But we can always go on our.
Yes,
It'll be £2,200.
Right. Well, what do you want to say further, Mr. Williams?
Prosecution point. Yeah, let me check it. Thank you. Well, on the point about the right to prosecute, it's important to appreciate that the court's decision suffers from lack of clarity, particularly when one considers the two judgments together. I would humbly recommend reading the Diah judgment first on this point, because it seems as if it was written first. And in the Diah judgment, well, let me put it this way, in all the judgments, the two judgments, the unanimous holding is that Indicom has no capacity. It's not a body corporate. And only persons and corporations can bring prosecutions. No authority was cited or relied on for that proposition. And we say the proposition is incorrect. We are saying incorrect in two ways. First, we say Indicom is a person or authority, or I should say and. Indicom is a person and an authority. And we say prosecutions are not limited to incorporated bodies. We're saying that at common law and by our Constitution, prosecutions may be brought by persons and authorities. So that unanimous decision we say is wrong to begin with. Indeed, we say the right to prosecute is one of those procedural rights expressly preserved at Section 34 of the Indicom Act. It didn't need preservation because the right to prosecute is such a strong and viable right. It exists unless expressly removed. But at 34, I'll take you to it, the Parliament expressly preserved any remedy, we say it's a remedy, or right of appeal, objection, or procedure given to any person by any other provision of law. It's 935 in the electronic bundle, please. So we say Indicom is a person and an authority. So that unanimous finding we say is wrong. Then, another unanimous finding is that the DPP's permission before charging a police officer was not required by law. Not required by law. Without taking into it, my lords, EB 467/182. EB 467/182. Another holding from both cases, well, from a Diah case, was a holding of Brooks J.A. and Frank Williams J.A. that the prosecutor, as the person who laid the information, can choose his counsel without the DPP's permission. Now, I have to pause to explain how this would have arisen. The Diah case was brought during the interval between the full court decision in Police Federation matter, that's the other appeal, and the Court of Appeal judgment. So it's brought in that interval, which is an interval of many years, I think over 5 years between the two decisions. And it was, although the full court had said Indicom could prosecute, it was being claimed that Indicom, although laying the information, needed to get the DPP's permission to hire a lawyer to conduct the prosecution. We argued that there is no authority for this. And it was constantly claimed. Indeed, there is a case currently at the Supreme Court, which is stayed awaiting this decision, where we were denied counsel of our choosing to prosecute the case, and the case was eventually dismissed by the clerk of the courts having charge of the prosecution. So it is a very strange view of the law held by some in Jamaica, that even a private prosecutor, or even any prosecutor, needs the DPP's permission to say, I choose this lawyer or that lawyer.
Well, in a sentence, your argument is that Indicom, in its private capacity, can institute a prosecution based on the information that it has acquired in the investigations that it has conducted. The contrary argument might be that by dint of affording Indicom the opportunity to investigate the particular circumstances of an alleged offence, that it would be incompatible with that rule, that it should also be able to resort to the traditional right to prosecution qua private citizen.
Well, I know. What we say is the general right to prosecute, which is the private, what is called the private capacity to prosecute, is the right exercised by all police, private citizens, and would be the right recognized by us. The common law doesn't know of two different rights to prosecute. It was always, which is why we make the point that private capacity, using the private capacity, doesn't mean acting in your private interest.
When you speak of the private citizen, I mean, I understand your position to be that it's not just a private person, but an authority
Indeed.
can prosecute.
Indeed.
And therefore, when one speaks about private prosecution, one has to be quite careful in
Yes.
the words being used, because you're not making a distinction, as I understand it, between the commissioner as an individual and the commissioner as an official. You say he is suing as an authority.
That's what I'm saying. And indeed, if you take the example of a policeman also uses the private capacity, which is what the board said in Stedroy Benjamin from Antigua. He is also using that private capacity because the right to prosecute predates the constable, the office of constable. So the constable, once they came on many hundred years ago, they were adopting the very private capacity or private right to initiate a prosecution.
Well, let me be clear about this, because I'm slightly troubled by your answer to my lord. Is Indicom, in this instance, instituting a prosecution as a private body or as a public authority?
As a public authority. And indeed, we are saying...
Well, where does the source of the right to prosecute, where does it derive from? If you're having resort to the status of Indicom as a public authority.
Yes, we are saying that at common law, all persons, and the definition of person is something I'll get into shortly, and public authorities, I should not need to add the word public, all persons and authorities at common law were able to initiate and conduct prosecutions. We're saying that is and indeed, that is the common law right. And indeed, we can see it in the Constitution, which says the DPP may take over prosecutions instituted or conducted by other persons or authorities. So the Constitution recognizes that persons and authorities can initiate prosecutions. I said the definition of person is also important, and I will say why I say so. The Interpretation Act of Jamaica says a person includes a body of one or more persons, whether incorporated or not.
Sorry, can you just say that again?
That the Interpretation Act says person includes in its definition a body of one or more persons, whether incorporated or not.
Yeah, but if that is your argument, that seems to me to partake of the submission that the authority, in this case Indicom, is to be regarded as a person, and therefore it's by resort to its status as a person that it takes the proceedings, rather than its status as a public authority.
I think there is no importance in that distinction between persons and authority. They exercise equal rights to initiate a prosecution.
Yes, but that is, if I've understood your most recent submission, that's because an authority must be regarded as a person.
No, I'm not saying that.
Well, why refer to the interpretation of authority then?
No, I will turn to the interpretation of person. So I was saying that the word person includes, of course, natural persons. It includes incorporated bodies, but it also includes bodies of one or more persons not incorporated.
Well, quite. But at the moment I'm at something of a loss to understand why you are not espousing the proposition that it's by dint of its status as a person, because it's an authority which comes within the embrace of the definition, that Indicom can take the prosecution. Now, are you suggesting that there's some standalone status which entitles Indicom, irrespective of its inclusion in the definition of person. There's some standalone status that entitles it to take a prosecution.
No, I'm not saying that. What I'm saying is the common law has not made a distinction between, as regards the right to prosecute, between persons and authorities. So the common law has recognized that individuals can prosecute, charities can prosecute, government authorities like the revenue can prosecute, and these have been recognized at common law.
Sorry.
No, I see. Well, perhaps I understand now. It's by resort to the common law principle that you say that Indicom can prosecute as an authority because of the spread of persons or individuals or associations or authorities that the common law permits to prosecute. But you draw in aid the interpretation of the Jamaican Constitution to reinforce that argument. Is that what you're saying?
Indeed.
Yeah.
I'm saying the Jamaica Constitution does not create the right. It recognizes it and continues it.
So are you saying that Indicom and its officials have the same right to prosecute as any other person?
Indeed.
Thank you.
Does it really matter whether Indicom itself, as distinct from the Commissioner, is or isn't an entity capable of prosecuting?
I'm sorry.
Your main submission is that Indicom is embodied in the person of its Commissioner from time to time.
Indeed.
Like a corporation soul.
Indeed.
Like a duke or a bishop. So, in that case, does this argument about whether Indicom is separately from the Commissioner a person really matter? Your submission will be just as good, presumably, if it's the Commissioner, who is undoubtedly a person who you presumably say that common law can prosecute.
That is my point. Because, which is why I took it to 3-2 in the law. The Commissioner, it is, we say in the office, it's like Louis XIV,
Yeah.
in that the Commissioner embodies the Commission. So to say it doesn't have personality is incorrect. It is the Commissioner. The Commissioner is the Commission.
As Charles de Gaulle said, vive la France et moi.
Well, he is a natural person who has been given authority
Indeed.
as Commissioner.
Indeed.
And you say that's the answer to the personality point.
That's to the personality point. And the principles, which I could take you to, is that natural persons can always use their private capacity in furtherance of their public office. Let me take it to that. I can take it that before the break. That is from Halsbury's. It is, I think it is, let me do Fiji first. I'll first take it to DPP of Fiji and AG Fiji. Volume 2, tab 27. Oh.
Volume 2, tab 27.
Yes, madam. I'll take the page shortly. The page is 1203. Yeah. Oh, it's volume 8, no? Page 1203. The background to this case is that the DPP of Fiji, the governor, or the governor general, had assigned the attorney general as to have some supervisory role over the DPP. And the DPP brought an action to question whether that was lawful. And one, could say, side issue in the case was, can the DPP bring a civil action, given that the DPP is the full code of the DPP's powers under the Constitution in Fiji, as in Jamaica, is that the DPP prosecutes. And there's nothing to say the DPP sues. So, so this is taken up very briefly by the board at the end.
Well, perhaps we'll look at that brief allusion after lunch. I suspect, Mr. Williams, you won't require anything like the time intended for to complete your submissions.
I am to go to 3:30 if
No,
you have
you're
me
not,
so long.
you're not obliged to do that at all. I mean, we seem to have made good progress.
3:50.
And so one would hope that it won't be necessary to take up the full time of the deputy. We'll sit again at 2 o'clock.